Okay, we'll grab something. We'll proceed.
So, Mr. Chairman, let me just think. So, those who are following, what you have agreed for clause 17 to the general provision in the constitutional provisions for various offices, as stated Mr. Speaker, as end of term benefits which they cannot take away from you. For this bill, we are saying you cannot stay in office because of this provision. But we also don't want you to be disadvantaged in getting the benefit from 73. So we have agreed that we will come with some conditions in making sure that when you are removed because of inability to perform the functions of their office due to physical or mental difficulty, you benefit from the particular promotion that 73 is talking about. So, Mr. Speaker, we accept and we can get a rendition.
Yes, that's it. Thank you.
Mr. Chairman, please let's get it clear. Mr. Chairman, are you listening?
Yes, Mr. Minister.
Mr. Chairman,
I'm sorry, Mr. Minister, your leader is up.
Oh, sorry.
Yes.
Mr. Chairman, I think we need a further clarification. If you only be paid, if in the case you are removed from office because you are mentally derailed or you are sick, let us get that clear. Because no one is situation where somebody will be dismissed, then the person asks for payment of his balance emolument.
Yeah, we have already agreed on that.
Thank you.
Yes.
I hope it should be stated.
Of course.
I think that the law currently actually makes that exemption.
Yes.
If you look at 17.3, the second paragraph, it says provided that where the National Security Coordinator or the Deputy National Security Coordinator is removed from the office before the end of term to which he has been appointed under subsection 1, he shall not be paid salaries and other emoluments in lieu of the remaining period if the grant removal falls under paragraphs A, B, and C.
Okay, it's already there.
So meaning,
Yeah, it's already there. Yeah, thank you. Yes, Honorable.
This is actually an administrative aspect of implementing the Honorable Chair, let us be mindful that when people in the executive arm of government are implementing these things, this is where our assessment, international assessment comes in. Like for instance, the area of when the bank governor was it was all over social media. It's remaining monuments, how much is to be paid, and it was to be paid in USD to his previous account. Those are things that we have to swiftly and agreeable settle them without getting our international attention. So that is just my concern with that. We do that in the law we passed.
Okay, sorry, noted. Yeah, Mr. Minister.
Mr. Speaker, Chairman, I think the points you raised on human rights is really important. And the 2D itself, inability to perform the function of the office due to physical or mental incapacity, is too general and broad and can be misused. And I suppose to your point, not linked to the emoluments, because we'll address that, how do you bound that such that maybe you say as advised by a professional or something? Right now, anybody can say it's too broad.
Yes.
I agree with you.
Certainly.
And I think let's protect it.
Yes, yes. Mr. Clark?
Mr. Chairman, let me comment. Yes, but I see the whole not to remove it. Yes. It's not open. Yes, it's guided. But the second provision, I forgot in fact, I just reminded me that I don't know about what to do why I got been told by my chairman that I brought in this law sign back that if I did not see it, I said perhaps because my phone forward. But the chairman is not open. In fact, we are following what you said, what you told us on the grounds of humanity. So when the super clause 17.3, we argue on the grounds that you can benefit from it. You make it come, you have years. So colleagues, we are now saying we want the benefits for coming under the exemption clauses was the exclusion of the. And he said it's really unfair. And I agree. But I said there is also a constitutional provision. I know. And what I've done, we have not interfered with constitutional provision. We are now saying because of inability, our colleagues too. They are suffering from that. And anything can be removed from that. But it's already established. But if the case is established, we now come to this provision that you're talking about. So it's not open, it's well guided. You understand? Now let me come, Mr. Chairman. You can the inability must be determined by some proof which you have not stated. No, so no. It's not open. They can now, this is administrative. They know the institution now will go further to get an administrative proof to your inability. We are living in a very cruel society sometimes. You have to understand. So you now bring in your regulation. What are the things that you look for incapacity or inability to perform? Mr. Chairman, I'm respecting.
Thank you. Yes. Yes, that's for page 22, honorable members, page 23, page 24, page 25. Yes.
Mr. Chairman,
Yes.
Page 25, I have sensed an element of absurdity.
Right, where?
Page 25, that is 22, where it is stated that the president may from time to time assign ministerial responsibility to the agency. Yes, I sense an element of absurdity which borders on the separation of powers. And you remember, severally I have cautioned this House when it has to do with security and intelligence related matters. We view it as strategic and not merely administrative adjustment, purely strategic necessity. Now, this one, I see it as being a very dangerous.
I just agree with you.
Yes, close. You remember historically during the Sarkozy era?
I totally agree with you. Did you see that, Chairman?
Mr. Chairman, this is not the first of its kind where the president has the responsibility from time to time as time.
No, we cannot give that blanket check. We cannot give that blanket check where the president has just choose any minister to take care of security. That will not be in the interest of the state.
Let me help to give a recommendation to that. The essence, the cardinal role of the NSTOR is to coordinate security matters in this country. Ideally, I would prefer that functions to be given. Yes, so, yes. Coherence. They are of coherence.
Chairman, can I observe? My colleague, I don't know, but I'm not convinced. I'm not convinced. But let me try to convince the chairman. Let me try to convince you. The chairman, first, you don't need to state if the president wants to give an assignment to someone. This cannot be overstated. It's just to make the document palatable in a sense, and to make a ministerial coordinating teams in terms of security sector to be palatable. But we are the president thinks it's necessary. You can assign an appointment or assignment to anybody. That's an authority power. So bringing in the minister is like a control mechanism in it. Try to give to the president that okay, you can assign this. But let me come now to the point. The general provision, the omnibus provision, why we have this clause given, is part 5, the Central Intelligence and Security Agency. This CISA is a very complex. We don't want to go into the operational aspect of CISA. So if you allow, Mr. Chairman, we can really ask the professionals that are with us. When it comes to intelligence, you should be careful in the wordings, to be careful in the operations. We can never be professional in this field as politicians. They have what we call sting operations. If they tell you how you talk about sting operations is here, but they did not go into the administration of it. They can even use sting operations. They are doing it in parliament. They are doing it whether we like it or not. When things are coming to the state, parliament is under scrutiny for certain things, they can do sting operation. Are we saying they have to come and explain what is sting operation for 28? No. And that's why I CISA, I beg Mr. Chairman.
Mr. Leader, you are still not convinced me.
No, I'm trying. Let me come now.
I want the
so that's what I said.
Talk with the minister.
So let us talk to them if we can have this clause.
Hold on.
Okay, you allow sir, Chairman, sir.
Yeah.
I want I want my chairman.
Yeah, the security coordinator, talk with the minister because I want to know the rationale. Yes, Chairman.
Mr. Chairman, it's clear on 20. It is under the authority of the president, this agency. So, the person whose authority this agency is under has that responsibility from time to time as deems appropriate. So, it's under his authority. So, it's referring to the agency there, not all other security matters, but the responsibility for the agency. It's just for this agency.
This is a security matter.
But it's under the authority of the president.
Security matter. Don't lose sight of that.
Yes, that's what we are.
Even when we debate, don't lose sight of the fact that this is a security matter.
Yes, you are right. Mr. Chairman, but let me tell you one thing.
But I want to know the rationale.
Let me now attempt to this another clause. Yes. If you go back to clause 23, there is a provision where clause 23, 418, they're talking about the national security auditors involved in talking about the inadequacy of resources and the validity of mode of acquisition of equipment, including arms and ammunition. That's responsibility going to them. But they are still being supervised by the office of the president. Now this one is clearly stated, Mr. Chairman. 20 is very clear that there shall continue in existence a Central Intelligence and Security Unit, the agency, under the authority of the president. So under this authority of the president, now this is the responsibility given to a ministry of authority of the president, which we call ministerial responsibility, and it's clearly stated, supported by the super clause 20 that given to us, that has to do with the operations of system. So that is quite I think we should accept because it's a very
Mr. Minister, let me hear you. What's the rationale?
Thank you, Mr. Chairman. This particular on 22, CISA, for example, in its bill has a responsibility to present its reports to Parliament, and the minister is the one who can present those things in Parliament, not ONS, called as an example. The president, who's the chair of the NSC, already can delegate to any of the ministers. Mr. Chair, the reason why we removed the Minister of Defense, is because Defense already has an intelligence wing, FISU, associated with it, and Internal Affairs has another intelligence wing in the police, which is the IIS, and CISA is independent. So you cannot have this wing also be for defense and internal affairs. This is why we gave the president the authority to delegate it to any minister that the president is speaking.
And is it appropriate? Is it okay?
The president can change anybody any day as minister. So the president, as chairman of NSC, has the liberty to know who is the minister. Most, because they're all on cabinet. and I suppose maybe if you do, I don't see a reason why to contain the president's hand in this, but if you want, you can say any minister who is on NSC that is not internal affairs or defense, because there are other ministers who are in NSC. But that would be too binding because the president knows a lot more than all of us.
Yeah, because I was thinking about the repository of knowledge related to security. Because you can't just get anybody from anywhere because assign security matters to them. That in itself is not being security conscious.
Yeah, I think first of all, the chair of the national security, the president can invite anybody in there, anybody to NSC at any time as members. Yes.
Probably will make that specific to NSC.
So to your point, we can't say any minister who is a member of NSC apart from those two. To your point, we can.
Mr. Clark.
Mr. Chairman.
Yes.
I think it's the language. He has not removed them. You see, he cannot be responsible. He has not removed them. Which one? This 12 are together for 22. He has not. He's just adding a layer of responsibility to other sectors. Now let us go. Let me read it carefully. Genesis 22, page 25. The president may, that's the first clause, may from time to time assign ministerial responsibility for the agency to set minister other than the Minister of Defense and Internal Affairs. These are people that their position is sacrosanct. He's adding a layer. Yes. Other than to bring them in.
It's all right. We'll stick a pin.
No, wait, before stick a pin, Mr. Chairman. He said, as the president may consider appropriate, that's only the level of professionalism when it comes to assigning duty that is of substitution.
It's all right.
So it is a well-guided law. It's well structured. They are not. I'm not sure they are removing the digital affairs and the. They are bringing a layer. Yes.
It's all right. We'll stick a pin for now.
Mr. Chairman,
Yes.
I don't want us to pass the law here with a single individual in our mind. For sure, we know that the current president we are having is a retired general, so he's very security conscious. But maybe the next SAP president we are going to get will not be a military man. The next SAP president will get come 2028 will not be a military man. No, I'm not talking about woman. Will not be a military man. Therefore, let us don't let this law having retired president at the back of our hand because it's a security man. No, he won't not be president in this country, not now. So, Mr. Chairman, that's my submission. Let us be open. Let
Chief, we don't go there. If you don't want trouble, don't go there.
So, Mr. Chairman, we are not going against it. The chairman is asking why you should delegate it to others. I'm supporting that. We leave it like that. We leave it like that. I'm not against it. I see you are the what I'm no. He has asked why we should leave it like that. Yes, we should. And we have brought in a lot of things. And that's why I read the provision today.
You see, when I sit here as the presiding officer, I see things things that you may not see. There are certain things I will see ordinarily that you might not see. You know, without being boastful, I've been a lawyer in this country for nearly 20 years now, and I know some of these little things, the damage they create. Some of these little things you overlook, the damage some of these things create, and the justification that will come out of whatever damage that is created. Sometimes these things are huge. You overlook them. You see them as just works. Anyway, yes, Mr. Minister, let me hear you.
The chairman for that. The chairman to save you from giving all the responsibility. when we have to just allow us to give the motion, whether we accept it or reject it.
That is when I allow the motion to be put.
Well,
that is my domain. Don't go there.
Mr. Chairman,
That's my domain.
because the spectacle we have, maybe we don't have it. We are lawmakers. We are not lawyers.
Is that right?
So that is what we are asking.
Leave that domain to me.
So, but that's what we are asking. But let me come back. Mr. Chairman. If we detail the dynamic nature of the security sector, the reason why some of these things you have to do the discharge of responsibilities. Even what the minister has said, he has said, like document in terms of laying with not annual reports. That is supported by the same force. You just have to delegate to a minister. Because that's what we said as it appropriate. Where you want to lay annual reports in the world of parliament, it cannot be the head of the agency. It can be a minister.
You have said so. You have made your point.
So let me now learn. So for me, under this public ministerial responsibility, Mr. Chairman, I think this clause is not a rigid clause. It's a flexible provision given to certain action to take place. I believe that we should maintain.
Yes, Mr. Minister. Can you try to convince me?
I think, Chairman, if you look in the composition of the NSC, there are 6 other ministers there, apart from the Minister of Defense, other than the Minister of Defense and Internal Affairs.
That is the language
if you interpret, there are 6 other ministers.
If we make that specific to the NSC, that's the more the merrier.
So what I was saying is, if you interpret 22 generously, as the president can choose any minister, then it could be any of the cabinet ministers,
Yes.
or you might say it is any of the 6 other ministers in the NSC. But I think if you leave it as this, you give the president the freedom and
and all of that. Okay, we'll stick in media. Let's go. We'll come back. Page 25, page 26. Page 26. Page 27. Page 28.
Page 28, Mr. Chairman.
28, yes, Chairman.
If I recall, in clauses 17, 1 and 3, we made some changes. Starting 28.1 also has to do tenure, wherein the changes we made in 17.1 are also applicable to 28.
Yes, Mr. Clark. Where is Mr. Clark? Okay. So take note.
And they're also applicable in 28 because these are the areas that we're going to explore.
Okay, it's all right. That's for page 28.
Yes, Mr. Chairman.
Page 29. Members, page 29. Sorry. Yes, Mr. Leader.
28. Sorry. I want to remind you, Mr. Chairman, what we agreed is still stated in the same provision. Okay. Yes, so I don't want to make a reminder.
And where is that? Page 29?
No, it's 28. Yeah, I'm not referring to what you give. That it should remain as it is in the same provision.
Okay, provision.
Yes.
Yes. Yes. Thank you. Page 29. Mr. Clark, do you know what the leader is referring to? Under 23, you provide so? Yes. Take that from what you said on page 23. Thank you. Page 30. Oh, 29.
As I said, you read the report. We should read without going page by page, so we can accept the report and target corrections to previous clauses. So,
We should go up to clause 35, is it?
no,
Oh, clause 31? Okay, clause 31.
29 should be.
It's
Is it
29.
not part 6, verse 30?
It's 29, not 31. Was there any adjustment?
Oh, part 1 to 6. Okay, they said part 1 to 6. So let me go back to clause 29, page 29.
Oh, to 31. Let me see the procedure.
Part 1 to 6. Okay, 31. Okay.
Yes, clause 31.
Okay.
So, Chairman. Yes, leader.
Mr. Chairman, as I said earlier, when you have read the report, you say we accept. Big content clause 29. So that has to do the Director General shall appoint such other staff. There is a typo here. So it will be read. I don't see the report now. I think this typo was taken care of. I just want confirmation from
Was that addressed?
yeah,
Oh, yes. The chairman said page 6 of the report.
okay,
Yes, the
so
chairman said.
you adopt the report.
Oh, yes.
Is that it, right?
Yes,
Okay, so we adopt.
yes. So we are sent with page 29 also.
Yes, yes.
Page 30. Page 31. Page 32. And part, the first half of page 33. The first half of page 33. Yes, Mr. Minister, we'll go back to where we stopped the page under 22. Are we okay with that? Or do we leave it that to the NSC, or do we go ahead as it is?
I think, Mr. Chairman, let's limit it to NSC ministers.
To NSC
I think your guidance.
I totally agree, my brother. I totally agree. So, Mr. Clark?
Mr. Chairman.
Yes.
Mr. Chairman.
That's the minister.
Yes.
That is piloting.
It's piloting, but I think I don't want to see where there's disagreement between professionals and our minister.
Is there any disagreement?
A bit.
No, there is no
Are you
disagreement.
sure?
No, there is no disagreement.
Yeah, with NSC.
There is no disagreement.
On
I
NSC.
think that's all
Let me put my piece.
I told the
Fight it down.
security committee to
Now,
again.
for me, I don't see in too much limiting the president.
Leave that.
No, I don't have.
Leave that.
Let me come. Let me land, Mr. Chairman. We are basically doing part of the administration of that position. I'm telling the president that he should take people from that. What about those who are not there at a point in time? The president wants to make an assignment to someone in another sector. It's not part of the NSC. Are we limiting the president just only to NSC?
Just take any other minister.
The president can continue with all the provision of NSC. You see it now.
No. Even common sense.
We are not saying that is why I said the clause is not rigid. But now you are making the clause rigid. You are not making the clause rigid. The clause is not rigid. The next rigid is not making rigid.
Yes, minister, let me
You are not making it rigid.
Hold on, leader.
Mr. Chair, I think the leader of government business makes a good point. You could imagine that the president is on a mission somewhere and he wants to assign a responsibility for CISA during that mission, and he can appoint any minister who's there. But if he can do that now anyway, that's part of the debate.
Let me tell you about the presidency. You see, all of these laws we make related to the executive branch of government, we only guide the process. There is nothing preventing the president from taking executive action. So by doing this doesn't mean we are limiting the president, he cannot do otherwise. He can still use his executive powers to appoint any other minister out of this category. But when we make the laws, we guide the presidency. We guide the executive. That's what we are doing.
I think, as you
He
said,
can still use his executive powers. For instance, there was something that happened, something that was supposed to have been signed by the Minister of Finance, and he was Minister of Education at the time, and they were out of the country, he told him to sign. And that document is legal. He came to this parliament. He has executive powers, unlimited executive powers. So, like doing that, we are just guiding him. We are just guiding the process.
Mr. Chairman.
So that is why, hold on, Mr. Chairman. That's the reason we should not put rigid clause in directing the president. That's the very most reason I said the clause is not rigid. Because section 61 of the Constitution is very clear. No matter what you do, and supported by 171, subsection 15. You should not say, except members who are in that particular set, NSC. That's what I'm saying. The clause is correct. I have said it before. We are contradicting ourselves. Once you are getting the president, we are also
restricting the national security coordinator.
You are still restricting the president.
I will still use my powers here soon. Talk to him again.
Mr. Chairman.
Talk to him again. Hold on. Let me hear the chief with you. Yes,
Mr. Chairman.
So hold on. Yes, leader. Yeah, proceed.
Yeah, Mr. Chairman, besides the points you've made, I'm pretty sure this document went to cabinet.
Yes.
It has the concurrence of cabinet.
Yes.
And the head of that cabinet is the president. He was in attendance when they listed those ministers here. So there is, we won't make a mistake if we restrict him to appoint the ministers from this document. This is his own document, because this document is from cabinet. So I agree with you. Let us say he only appoints ministers within the NSC.
Yes, Minister.
Because if he wanted to appoint other ministers outside the NSC,
it's all right.
they wouldn't have stated the ministers here.
It's all right.
Mr. Chairman,
Yes.
Mr. Chairman.
Yes.
There is no nexus.
Yes.
In reading this provision, clause 22, in tandem with what you see.
It's all right.
There's no nexus.
It's all right.
So fine, because thank you. I rest my case.
Then, Mr. Minister, I just want you to convince me.
Mr. Chairman, I think the vision behind the points that you made is clear. I accept the reasoning. At the same time, I understand what the leader of government business is saying. And if you think about food security is a security issue. Environment is a security issue. Lands is an intelligence and security issue. So I think allowing the president at that moment, from time to time, to delegate to any other minister, including those who are outside the NSC, makes sense for those reasons. I think it's, as the clause says, from time to time. So ordinarily, the president is the head of CISA, he's supervising CISA, ordinarily and normally. So this is just for specific instances, like go lay a paper, go sign a document, go do something, in which case, then it should be anybody who the president deems fit for that task.
So you agree that we leave it as it is?
Yes, Mr. Chairman.
Okay, we proceed. Now, do we have any other areas where we stock things? So we are set? Yes, Mr. Chairman,
Proceed for the edification. I don't know if the intent when we met is the same or two share. The 2+1, the minister led to it. We have not seen the communication of that.
2+1?
Yes. The 2+1. No, yes. I know I said Mr. Chairman, when he said he want to see the text of the bill presented to the president, I nod some point to it. I did because those clauses, when you change them, it will affect the intent of the act of the particular provision. Let me tell you now, section 58 of the Public Elections Act 2022 is affected by freezing. Definitely you have to amend it. You have to amend it. So I just want you, sir, through your good office, can we see the physiology of that too also? The minister said, because it was very emphatic if I stood up. I said, no. At least one. So I want us to see the physiology. Okay. Yes, that's all right. That's it.
Yes, Mr. Minister, proceed.
Mr. Chairman, before I proceed, I just wanted to state that on this matter, it is very important that it is at least not one, because there can be 3 women on that committee, on those. With that said, I want to thank you in this house for the wonderful debate. Mr. Chairman, honorable members, I move that parts 1 to 6 clauses 1 to 31 stand part of the bill as amended.
Once you don't use it,
Honorable members, the question is that parts 1 to 6, clauses 1 to 31 stand part of the bill as amended. All those in favor say aye. Aye. Those against say nay. The ayes have it.
Parts 1 to 6, clauses 1 to 31 form part of the bill as amended. Parts 7 to 11, clauses 32 to 59 and the schedule stand part of the bill.
Mr. Chairman, honorable members, I move that parts 7 to 11, clauses 32 to 59 and the schedule stand part of the bill.
Honorable members, the question is that parts 7 to 11, clauses 32 to 59 and the schedule stand part of the bill. The remaining part of page 33.
Yes, Mr. Chairman.
Yes.
Taking us back again to page 7 of the report. Yes. Surplus 1 of 32. Yes. So the composition of the category. So 1A should read the president, the vice president, speaker, and chief justice and their immediate families.
Noted. Mr. Clark, take note. And in B,
B, the following special categories of persons. Of course, former president, former vice president, the speaker,
former. Former speaker, former chief justice. Because you've dealt with
yes,
them
yes.
again.
Okay, the whole house is going to agree on the order now. We are going to. I was going to another angle where you have the speaker and the former speaker.
Yes.
So
yes, you have the speaker, you have the chief justice again. That is when they are in office.
yes.
Then after office, you have former presidents, former vice presidents, former speakers, former chief justices. Then you come to the leader. What we agree.
Again, you're leaving out the speaker.
The current speaker is in A.
Yes, okay.
The speaker is in A.
Agreed. Yes, got that.
In B, you deal with former presidents,
Agreed, Mr. Speaker.
former vice presidents, former speakers,
yes.
former chief justices.
Agreed.
Then you come to the leader of government business.
So the speaker and chief justice in Roman figure 3 and 4 are replaced with the former speaker and former chief justice.
Yes. Yes. And you have, okay, the leader, what we agree.
So now, yes, it's just the order now.
Yes.
Well, I'll read it, then we'll do the order. Again, what we agreed, we have the majority leader and the deputies. The leader of opposition and the deputies. Then, of course, we have the Supreme Court judges. We have the ministers, visiting heads of state, other designated very important persons. This is what we agreed. So now we just have to put them in that particular order. The new additions, majority leader and his deputy, leader of opposition and deputy, Supreme Court judges. These are the new additions to what we currently have there. So we just have to put it in the order that's
and other designated very important.
Absolutely, it still remains.
Page 34.
Mr. Chairman,
Yes.
let me start.
Yes, the deputy speaker. The deputy speaker.
Yes, the deputy speaker.
Yes.
Mr. Speaker, again, I sense with regards to the protection being provided by the SPS as being very expansive in scope. In this vein, I may firstly want then to define the immediate families. One. Secondly, you cannot mention all of those responsible people, including ministers, leaving behind the city MPs, for which I stand to recommend that the city MPs be included in the protection. I rest my case.
Yes,
First of we have to face with the reality of the day. We really have to face the reality of if you take the number of MPs, we are on 143, 49, sorry, 149. And ministers, there are 20-something ministers. But depending if you have somebody who is coming, maybe we like we reduce the number of ministers. But now we have 20-something, couple up with the deputy ministers, we may not 30-something. But let me say, if you say by even every MP, we exhaust the numbers in the police. So why? Now listen now. There is the argument I'm putting. Listen, you are going to talk. So what we are saying, if you take over 149 MPs, on a police officer assigned to every, to be very honest, the MP don't need security for the moment. So what we are saying, look under the category of some, maybe they don't need some. Everyone else in the opposition, I did not require security, for obvious reasons. So, no, let me come, please. Allow me to land, please. If you want to speak, you.
Yes, proceed.
Yeah. So what we are saying, if you look at we can say we brought in the Supreme Court judges. You know there are other judges. Don't forget there are other judges. Or say specifically, we cut off at the Supreme Court judges because the number is small and looking at the functions that they do perform. NPC again, we came down to the leadership and you see provision was not paid for chief whip or the whips. We only limited them. Every deputy was under questioning. It was a back and forth with the professionals. And they can provide for the majority and the opposition, but for deputies difficult. In fact, the minister went as far as saying, we should maybe remove the ministers. He said, no, whether you like it or not, the president will assign them security. We tell that issue of cabinet. So we want to be plain and really focus and look at the reality we have. If we put 149 police officers, we assign to MPs. That will be very realistic. The number in the police force will be affected in it. So what we said I'm coming. What we said after serious consideration, we should now look at in the provision where we said you can give security personnel where necessary. We structured that one and they made a commitment. And that request will come from the Clerk of Parliament, which is our own Parliamentary Service Act. For our own Parliamentary Service Act, it's clear. If you check, the Speaker is giving protection, former Speaker, a current Speaker in the Parliamentary Service, a current Speaker in the Parliamentary Service Act. It is there. And we are about to do that amendment. I am not saying you have right to have security. We are just being very cautious and be realistic with the present circumstances we are. That can we give one-on-one to MPs? Can we remove the ministers? If we remove them, they will sit in the cabinet and take decision and give instruction to the IG. No matter whether you put it there or not. So we say we want to be realistic, let them be there, and we add on layer. If you have looked at the proposal they brought in fact the speaker is not there. They did not put in place the Supreme Court judges. They just said ministers. It's not possible that we can have ministers running this state. Because they are the executive, they control the security of the state. So we said, we are lawmakers. That's what I said, we are lawmakers. Let us have categories and give consideration to the general membership. But it's a very bitter argument we have, but a challenging one too. So it is still in a transition, Mr. Chairman.
This is how
we have the ruling, but don't making the explanation so that they can understand where I'm coming from. That based on reality, 149, based on reality, the present circumstance. Even when security personnel are assigned to premises, when there are issues, they remove them. They remove them because they want to pick up the numbers at the various points in time locations. Yes. So we are saying whether you look at it in this way, that can we really have 149 given to every member, or can we say can we on request basis? That's the question to be answered. Thank you.
Yes, honorable members. Yes, hold on. We had this discussion lately, and it came to the point where the security experts said that this group is a specialized kind of security, and they are going to recruit just a limited number, just a small number of security personnel in this category. So we agreed, the leaders and I, that we will do the relevant amendment in the Parliament Act. The Parliament Act will have to be amended. Of course, we are working on that to ensure that that provision for the provision of security to the MPs will be done in the Parliament Act and not this time, because this is a very small group of security personnel that will have specialized training. So we had this kind of discussion.
Mr. Chairman, yes. Mr. Chairman, wait. No, I think you have to understand why I use the number. It's not, this is not.
Because that's why they did not include other judges. They just said Supreme Court judges.
Yeah. Mr. Chairman, I think that is misunderstanding the point. Please, if you raise it, please, madam. Please. Let me, I think that we should make a point here. This is under the rubric. Under the rubric, the State Protection Service. Members are talking about General Police Force. No, it's not General Police Force. So that's what Mr. Speaker said. We can treat a general assignment to personnel. This is purely for body for protection. They are trained in it. For the general assignment of the General Police Force to a member, it has to be in our Parliament Service Act, assigned a request by the Speaker of Parliament to the clerk of. But this level is a different level of security personnel we are talking about. This you cannot have, they cannot be up to 100. They cannot be up to 100 in this sector. It's a small unit. It's a small unit. We are having a police force. So hold on, please. No, hold on. If you don't understand the text, the content of the State Protection Service, if you don't have the numbers up to 150, or even say you have 200, and you have all the personnel, and MPs alone, you give the State Protection Service, it's not a general police force. I'm still calling attention. It's not a general police force. It's a special force. Okay, thank you.
Mr. Chairman, let me just have to resolve this by asking a question. A logical question.
No, you should resolve it because you started it in the first place.
Can I ask a logical question?
Yes.
Can we know the numerical strength of the proposed SPS?
Yes, that will be sorted out by the security experts. We cannot determine that here now. That is in their domain. Yes, William Flaming.
Mr. Chairman,
I don't want to open the floor.
Let me observe. Even if we know, we cannot allow them to disclose. But you can't. We don't do that. Yes, so he's the chairman of defense. He's chairman of defense. He's chairman of defense. I asked you to withdraw that statement. No, it should be withdrawn.
It's withdrawn already. Yes. So, William Flaming. You don't go deep.
I'm not going to.
What do you want to say?
Analysis, sir.
I want to say something.
Okay, hold on. Yes.
Thank you very much,
Hold on.
and Mr. Chairman. I've been listening carefully, talking about security, and we are talking about numbers. We are talking about numbers here. And if we say the immediate family members of president and the vice president, and if we want to be very sincere, I want to recommend that if we are talking about numbers, and for the vulnerability of the female honorable members, I would therefore recommend that you include the female honorable members. Because they are very, very
It's all right. It's all right. Yes, we are
Thank you very much, Honorable Chairman. We are all representing people. We are serving the people of this country. And then in the tribune, somebody is appointed as a minister or representative. They are all, if these special security forces are very limited, then we exclude the ministers. Because MPs and ministers, they are people, they are serving people. Yes. So what
okay, Saturday. In fact, we had that discussion also.
Yeah.
Chief, yeah. We had that discussion also.
Mr. Chairman,
yes.
I've seen this gentleman. We move around in Freetown at the beach on weekend. He's driving himself. He's going everywhere. No police officer. Our chief CM. I've seen him. Yeah, it's a people's.
You don't know if it's special boss.
Mr. Chairman, our parliament prayer is to thyself in his youth. We cannot say because us MPs are not having, therefore ministers should not have. Yes, I think let us stay with the appeal we are making instead of us excluding the ministers also. Mr. Chairman, we are talking about special security forces here. We have to be very, very careful. It becoming we are treating some type of severity. So, Mr. Speaker, I believe some of those debates or those arguments, in your wisdom, you should just put a stop to them.
It's all right.
National security is not a matter of fancy.
It's all right. No. I'm not allowing any other debate on this.
Mr. Chairman, just
honorable members, sit down. No, sit down. Just allow the leader.
Okay, Mr. Chairman.
Let's not open this to
Mr. Chairman. So thank you very much. I just want for neatness of proceedings and the preserving the sanctity of the law.
Yes.
That is my word.
Yes.
Preserving the sanctity of the law. We are not saying the majority leader of parliament and opposition leader they are male or female. They are not. In as much as I support our female folks in the house on gender basis, that's why if I asked Mr. Chief Minister to clarify, he was even making point of clarification at least because he knew where it was coming from, and he alluded to it by even making another pronouncement about it. It can be male, it can be female. It can no please man. It can be male, it can be female. How can you say, if you talk about it, try to watch than the effect of gender? It would have been disadvantageous, or not being in disadvantageous position. We have found a situation, a female deputy speaker of this parliament. So there will be a time, those who be our speaker. So we are not saying it is a very quality. We have been generous. If I say you are not saying, so when you say his, you can say, okay, don't remove his. You can say his or her. In law, his is a general description given to gender. His. So we say leader of the majority leader of government business or the opposition leader. It goes from male or female. We don't need to be specific in that. So that's precisely the story.
Thank you. That's on page 33. Page 34. Page 34. Honorable members. Chairman, page 35. What are you laughing at?
The way Mr. Chairman you have concluded this page 33, you know?
No, hold on, page 34, page 35. Chairman, are you following up? Okay. Page 36.
Page 36, Mr. Chairman.
Yes, 36.
Page 36, we have to incorporate the same changes we had in 17.1 and 28.1.
Okay, take those, Mr. Clark.
And also the proviso that follows. Okay, that's
yes. Take note of that. Chairman Legislative, let me see this bill when it is printed out. That's for page 36. Page 37.
Page 37, we delete D.
We delete D. E now becomes D, also.
Mr. Chairman, can I ask you to pause for something?
Yes.
Please, let me check the question. Chairman, there was a layer which we were so interested in. A layer that has to do with reporting and day-to-day activities of supposedly who should be the under the SPS. Under the SPS. So we agree in principles. I don't know if my colleagues are following because we still have to legislate somewhere about security personnel per MP. No, it's not here in the service event. Let me draw attention to something. Mr. Chairman, we said the nature of the SPS, the director. We know the president is giving directives, the authority of the president to have the senator, to have the DGA appointed based on other institutions. We made a commitment that we should now cannot state who on daily basis to report to. We agree that administratively it can be addressed. Mr. Chairman, administratively we said it can be addressed. So there's a provision which I want a commitment from the minister that has to do with the statutory instrument that takes out the regulations basically for administrative actions. And this provision cannot be oversight or overlooked because it is indeed clauses. There is no clear line on the daily reporting, but we are convinced by the explanation at that moment in your conference room that they will treat it administratively. They treat it administratively. We want to have it on record, Mr. Chairman, and the minister tell us the DG of SPS based on administrative structures will be taken care of. Let it be in the records. Just want to be in the records. We are not going to the integrity of the administration. But that commitment that was made, we want it to be stated from the minister. So they are not a lacuna. One day, the DG can be a different person of mine. We are all human beings. I will tell not to listen to anybody. And in fact, there will be a time when the board, they have their own structure of calling board. They don't sit every day. They have the time they sit at the case to be. Just a control mechanism, thinking about what they are going to do, so that the administrative aspects, which can be handled by them effectively, their professionalism, can be taken care of under regulations of this particular bill. Mr. Chairman.
Yes, Mr. Minister.
I think, Mr. Chairman, the point that the leader of government raised, I know we had moved on the first part of the bill But I think it's important because it applies to the CISA as well. The decision that we had made for the ONS code on 17 to 17.3 should be applicable to the DG CISA, which we didn't insert. So I'd like to go back there to look. Okay, for
Yes.
DG CISA.
Yes, we did in 28, but it's also going to be applicable here in page 37, dealing with clause 36, the director and deputy director of.
So if you that's what you're raising there, yes.
What you said, I raised it, and Mr. Speaker gave the more to it. The one I'm talking about is the one that we made commitments that we cannot state it here. We said who the DG of SPS can report to. They said they have a structured board, what we call councils. I said the council can meet in once in a while. We're talking about daily activity because security sector the dynamics. They said yes, they know, but we cannot now state in B where you should report on daily basis. But it is clear on principles that you report to the president. But we said no, we must have somewhere stated not to create lacuna. Where the DG can report to someone on a daily basis. See, and they said administratively it will be taken care of. We are not saying you should explain the administration of it. We are just saying the commitment you made to take care of that one under the administration. We want that commitment to be reinstated for the records.
Just say that for the record.
For the records, sir.
Do you want it stated in the bill?
No, we give you our records. Because it's a commitment that you are going to bring a statutory instrument. Mr. Minister, let me make reference. I'm not talking in vacuum. I'm talking in line with section clause 58 that has to do regulations. So, Mr. Chairman, why am I asking him to be committed? Instrument, this is coming in form of a statutory instrument. You know that specifically. How do we do statutory instrument in section 170 of the Constitution? It's a complex issue, and it is not taken care of in the instrument of regulation. You know we cannot do it. So the commitment, we don't want, in as much as we are supporting the executive, we want to have this caveat coming in, so that this will be control mechanism. The security sector is so free that we care for all these security. So we don't want to have lacuna in the totality of making law. But if there is lacuna in the bill coming as an act, in the regulation we should not create lacuna. There should not be administrative structure taking care of the lacuna in the bill, in the act. So that is what I'm just need a commitment to have a reference point for the regulations.
Mr. Chairman, the commitment is guaranteed and assured.
What is guaranteed and assured, sir?
What to do?
We don't know what is guaranteed.
Leader, what I want you to do, move a motion to that effect.
I please, sir,
I don't carry.
No, I don't want to blast them. When I move a motion, I will try to blast them. They told us, I want to give them the view. They talk to us that they will do it. They explain explicitly to us professionally, all of them, that yes, it's something, but these are things they take care of administratively. I don't want to be emotional. I see I'm blasting it. On the spirit of having a decent legislation, let us have it clear that the reporting system of the SPI and other security apparatus will be taken care of through the regulations. And the regulation, I'm going to say report to A, B, C, and D. It's just the mechanics of it we are talking about. Yes.
Mr. Chairman, I want to assure the leader of government business in this house that the day-to-day administration will be taken care of explicitly in the regulation that will come forward.
Okay, all right. Thank you. That's for page 36, page 37.
Still under 37,
D is deleted.
yes, we have a few issues.
Yes.
And 37, 36, 4 under page 37. That's where we apply the changes we made in 17.1, 28.1. Of course, applicable as well. Okay. Following the provisions. Then 37.3. We delete D again.
We delete D.
Yes. Then E is modified. It's the holder of a bachelor's degree from a recognized university with 5 years proven
experience and expertise, intelligence, and security.
Okay, is all right. Take note of that. Clark, take note.
Chairman, I cannot ask for the complete wording. I know he's going to do the edition so that we can look at it in the final draft. Let me remind you that conformity of the law is very important. When we are in that room, I agree, all of us. And in fact, the director of CISA said we should have the same before we have the CISA for obvious reasons. This is in fact, we shouldn't have gone through all those amendments. Should have been bigger an amendment, bringing this particular sector into the security law. And now we are seeing giving a qualification. We had a problem of qualification of the PG and the DEMS. We said it should be in conformity with other agencies, with that of the CISA, with that of the Office of National Security. We want to remind the chairman that we should not fall short of any of the provisions that we are given. We have not read all of them. I believe we do the needful, but we should do it in conformity of the infrastructure as well as in existence. Thank you.
Is it noted, Chairman? Chairman?
Noted.
Noted. 38, page 38. Page 39. Page 40. Page 41. Page 42. Page 43. Page 44. Page 45. Okay. Page 45.
Page 45, the first issue is 51.2, which is going to be deleted.
Deleted.
Yes, because it falls, that has to do with oath taking. The one that says to be sworn out of office in accordance with the oath of secrecy. If at all you're sworn out of office, then it means you're not under oath in terms of confidentiality anymore. So that's sworn out of everything. So it was like an oversight. So we deleted that page 45. Page 45. In fact, it was an issue that you raised. Now, number 52. Confidentiality. When you look at the current 52, it addresses members in the sense that serving members of the council in terms of maintaining confidentiality. But again, in our discussion, we agreed that even former employees shall not disclose. So there are some suggestions on that former officer, employee, or agent of the service shall not disclose any classified information obtained by virtue of his or her office except as authorized by law. Then another follow-up clause, the obligation under this section shall continue for life, notwithstanding the cessation of employment, retirement, resignation, or termination of appointment. Then it is followed by a penalty. So it means you have no right to disclose, even when you retire. You resign. So even after that, there is a penalty. So we even have to agree on the penalty. First of all, agree that we accept this provision that even when you retire, resign, whatever it is, you shall not disclose except authorized by law. And then, of course, what should be the penalty if you fail to adhere to this particular section? So we have 52 to see how we can have additional provisions. So we have 52, 1, 2, and 3.
Yes. I think we are making, we said we don't know what happens to in terms of confidentiality. We don't know. Security matters cannot be monitored in terms of penalty. Cannot. Because we don't know what has been disclosed, that there is so much in the domain that has to do with security. So much in the domain. So I propose to inquiry that we should not put money, we should put imprisonment because of the nature, the sensitivity of what is in their domain. We are doing it as
is that on page 45?
Yeah, 45.
Yes, that's something that we are going to add in.
Okay, page
Yes.
45 under clause 52. Okay, proceed.
because we don't know what they have disclosed, but we do know there is so much in the domain of these professionals. For over years, they have so much information. So I said, if you can disclose that information to me, vital, I give you $1 million. I come and find you $110,000 or $200,000. Has nothing to do with me. I will pay the money. But when you restrict, because we are making a crime not lucrative, we are making it punishable. Because we really cannot know the nature of what has been disclosed, or we know what is in their domain, we are preventing them not to disclose. We are preventing them not to disclose. For me, I said we should put an imprisonment of nothing less than 5 years. Nothing less than 5 years. So, Chairman, that is my proposal. Money issue on this is can water down. No, you don't know what has been disclosed. They have so much. The NS code of this country. If you don't know, they have the information is in their domain. It's so much that they are going to see can serve. They are in governance, they appoint you, and the opposition will come to appoint you, you still there, you serve both. What you are preventing is a disclosure of those secret information. They are very secret. How can you monetize it? So we make them punishable by law. So I said I'm pushing for not less than 5 years in prison, not more. If you want, you can put your proposal. But I'm on record that I want to make this particular aspect of confidentiality punishable by law. Thank you.
All right. Mr. Minister. What have you got to say?
We agree with the general sentiment of the leader of government business. However, we think that maybe 5 years is too much. We can limit it to 1 year.
Not less than 1 year.
Yeah. That's the
minimum.
Mr. Chairman, remember when we are pleading with you that we don't want to tie the hands of the judges or the judiciary. We don't want to interfere to them. But we guide them, we try to see the minimum bar. When we are doing the anti-corruption or other things, we refuse to place certain penalties. In fact, now we are going to the matter shipping bill is in front of us. We have a challenge now, talking about penalties. And we are discussing that and we have received letters from the court authorities. But let me come to this one specific. Why I propose 5. 1 cannot mean anything. I am talking about the nature. I do know, you cannot take that out from me, that the NS code has so much information in his domain. But what I cannot say, what is intent or he has done, or those who have not disclosed confidential information to the third party or second party, third party, but the second party is it. The first received, that is why they try to scrutinize to ascertain the veracity of information coming in before giving it out to the second party. For third party, when you have asked after your change of office, let me tell you, it has happened. They know, and it's happening. So we want to make sure we stop such practice in state in order best practice. You don't do it. You take off your life. You'll be in prison for life. Some are assassinated. It's a story all over. We are not saying if when so much of money, it's everything we need money for. Protecting the state is paramount to everybody. So disclosure of confidential information of such nature in their possession, it should not be 1 year. I can agree at least not 2 years to start from that point. And we leave it at the domain of the judges now to go above what we then 3 years, 4 years. I'll go for this. We will not be about 2 years. And the NS law should not be campaigning for us on that. Because you see so much information. We should be impacted in all that we should not even put less than 5 years, we should go 10 years and above. So I move for 2 years or 3 years. Any second?
Yes, the whole matter chiefly, it can be, when we say not less than 1 year, when we say not less than 1 year, it can even be 30 years.
Exactly.
The issue is with the circumstances of each case. Sometimes, information just leaks out like that. Even without your real intention. Maybe you are careless about it, or you are negligent, and that goes up. We know about stories. We know stories about people who insisted on particular laws, especially related to treason. And the laws they insisted were the very laws that killed them. Sometimes, when we make these laws, we are careful. It can be inadvertent. Something happens inadvertently, and the information goes out. You say, and as long as you are found guilty, you go for 5 years. Maybe for just negligence. So that's why we need to be very careful so that the judges too can look at the circumstances of each case and use their discretion reasonably to say, okay, well, he did not, intentionally, it's because of this person who will give it the money. But if it's 5 years, and there is negligence somewhere, they give you 5 years. Because that's what the law says. Nothing less than that. So that's why sometimes when we make these laws, we are careful how we do them. Somebody was caught in the act of corruption for 50 years. The police officer, collected 50 years from somewhere. The number of things to do. But it was corruption in any case, and it was found guilty. And the law stated the particular punishment. That's why sometimes we look at circumstances. We give these judges discretion to use their discretion in some of these circumstances. But if they say not less than 1 year, and somebody deliberately takes information to compromise the security of the state, then that person can be given 40 years, 50 years. So please, when we do this, let's be a little careful. Yeah, Mr. Minister.
Before Mr. Minister,
Yes.
I followed very attentively, but I decided not to flow with the sentiments you expressed. Because 2 things. I am human. I'm not a perfect being. Anything can happen in the future. When I'm very futuristic. I'm also very careful of protecting the sanctity of the state. This is what I'm talking about. It's happening now. Somebody who was going to the Office of National Security, to the domain of the NSO. In fact, that's why the way this one is worded. It's not like you are taking it carelessly and you have to be charged for it. If you look at the wordings, they are talking about documentary, deliver over it, publish or disclose the content of the document, communication on information which relate to these functions and duties under this act. So they'll be careful in what they go for.
That's very obvious. It's not specific.
Let me learn. This is what I'm talking about. Somebody who was on social media talking openly about the Office of National Security. Once accomplished under the NCSU. The NCSU, making it as a political tool to satisfy the people. We can understand the political dynamics. But they're not too mature enough to deal with it. So because we can't say very humans. So please.
Yes. Yes.
When I began to speak, you really talk about me, so I can take how you should fight. It scared me. It's coming from it scared me.
Don't
Mr. Speaker, I will not answer him.
be careful. The meeting, Chief Minister also is from Kujang.
Time is past 12, and therefore, I will suspend the SO5 so the law of the business will continue his argument.
Any second?
So second, Mr. Speaker.
All those in favor say aye.
Aye.
Those against say nay. The ayes have it. Proceed.
Mr. Chairman, I don't want to see the leadership weak. I will challenge your motion. Yes, I will tell you something about it all. You said we challenge. Mr. Chairman, if you have looked at the text given and look at what you have proposed that careless or whatsoever, we know we are humans, I say. I'm human, I can have affiliations. But we are talking about the states, the intent of the deliberately to bring disrespect or obstruction to the office of the security sector is what we are trying to address. I did propose 5 years. Now you said you have expressed interest that let us make 1 year. I said, well, maybe it's a proposal. I'm not a static being. I'm a very dynamic man. I can take either 2. I also plead with you. We not less than 2. Thank you very much. Because we don't know the nature of the social media and the AI. As I said, we don't want to make crime lucrative. We want to make them punishable by law. So giving the latitude to the judge to decide, though I first proposed 5 years, now I'm looking into what you have said. I will now come back to say, Mr. Chairman, with humility, I will say maybe 2 years, at least 2 years, with all other adjectives attached to that 2 years.
No less than 2 years.
Yes.
That's fair.
Thank you, sir. Thank you very much, sir.
It's all right. Yeah, yes, that's for page 45 also.
Mr. Chairman, I want to take you back on a sensitive issue. There is no 40.
Page 40.
No, plus 40, page 38. Page 38 plus 40.
Page 38.
Before I move, let me turn to address. We can even legislate under the SPS to say every MP wants security to one under the SPS. But it's also the domain of the executive to say feasible or not feasible. Let us don't make law if we cheat. Let us make law that we can imitate it. No, I'm saying we can do it because we want to satisfy our colleagues. I want to say, when I'm talking about addressing, he said that we can come and we accept. But trust me, we cannot address it in the Parliament Service Act. We want this thing to be taken care of seriously by Parliament, taking into consideration the seriousness of our security. But under the SPS, they are not going to be up to 200. Ask anybody. They are not going to be up to 200. This sector is already existing. But Mr. Speaker, I'll come to that. I don't want to allege the fears of my colleagues. Yeah? It's a reality of the law I'm talking about. Come back to what I was talking about. Page 38 plus 40. I don't want this clarification under part 8. Part 8. He said, warrant. I know this has to do with sting operations. Sting operations. But he said, one, I don't know if my understanding, but perhaps these security professionals will advise us or explain to me for my edification. We are the Director General as reasonable cause to believe that a warrant is required to enable the agency to perform any of its functions. It shall apply to judge or magistrate for the issuance of warrants. This is under who? Is it under the CISA? Is it under the NS code? Is it under the SPS director? So it's under CISA. So how do you capture that one? Is the sting operation stated under CISA? Then here we are talking about sting operations. Just can you direct us, please? Just we want to do it. All right. He's taking care of. I respect you. Thank you. He's taking care of.
Page 45. Forty-six, 47.
Mr. Chairman, before that, Mr. Chairman, this is a very serious matter. Mr. Speaker, we have faced with this on several occasions in the way. I want my colleagues to pay attention. Mandate, I did say there is a popular section of Constitution, there's a popular provision of Constitution, 93, very powerful. Mr. Speaker, when I was doing my presentation, even when we are arguing about how do we do the flexibility of the law, very president can assign not to assign. Very recently, I've been asking what's the operation director general, as I talk about strings operation. Carefully, they told me what they have to. Mr. Chairman, disclosure before Parliament. Disclosure before Parliament is very important to look into this matter and for this to understand. We said an employee shall not be required to produce before Parliament a document on other relevant or other evidence.
Which page?
Page 46, cross 54. I am not challenging the provision. Instead, I want us, all of us, to have an understanding because this security issue, and this is Parliament, we are not legislating to water down our powers. We are not legislating to water down our powers because this provision of disclosure of evidence before a committee is enshrined in the Constitution. As I said, 93 Constitution is very powerful. But given so the nature of the security sector and preserving the security apparatus working in terms of having the disclosure to be guided, we are and when necessary. They have deliberately brought to this house to look into this clause. For me, I support the clause. But for the house, I want us to really look at it and we accept. Because when you are writing a letter for disclosures of someone's institution of under this food, under the security sector, we should be mindful that you have legislated that has to be disclosure of Parliament. So, Mr. Speaker, Mr. Chairman, I want, under your directives, if anybody has objection to these laws, let us state it. But this is clear in the law that we should be seen protecting the secrecy of our security sector, making it very secret. So we not like me, if somebody will go outside, Mr. Chairman or Mr. Minister, always yeah, maybe Mr. Minister already passed. No, we know that to override a constitutional provision is not an easy task. But you bend backwards to make sure you make accommodation for the state, for the sake of the state. For the sake of the state. And every time we are writing section 93, blah, 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 blah. So I just want to draw the attention of my colleagues through your good office for these provisions stated in the bill. I rest my case. For me, I said I'm not opposed to it, but I am not alone in the chamber. But chairmen give responsibilities. They are always making reference to this provision. So if you are giving it up only under the security sector, we should be mindful that we should not make reference to the way it comes to this legislation. Rest my case. Thank you,
Mr. Chairman.
Yes.
We also be mindful of section 17115 of the law norm of 1991 Constitution, that wherever that section contradicts any of the laws we pass, the law norm supersedes them. So I don't think we should worry about whatever is stated in the Act, but we have to be mindful that the Constitution will supersede all other things that we pass.
Yes, I have a
Let me observe this. I know this will come with the limits. Mr. Chairman, I don't want you to come and just advise. Now, you know, caveats making some provisions is very important. I don't want our colleagues, because I've seen when we are talking about security for MPs, making it realistic. Actually, I understand. Also, this is the democratic right given to them. Now, to you, sir, I was looking for exactly what you have said to address it. And here comes in Mr. Speaker. Mr. Speaker, under the same rubric, we have the side note where we said disclosure before Parliament, and there's a caveat in page 47. They said, where there is doubt as to the nature of a document of all our evidence under subsection 1, the Speaker or the Council, as the case may be, shall refer the matter to the High Court for determination as to whether the production or disclosure of the content of the document or other evidence would be injurious to public interest or, as the case may be, prejudicial to the security of surrounding. So there is a caveat. Mr. Speaker, as a lawyer, you are addressing us. We don't also want the security sector to misuse this provision. So there are these caveats. So we are asking for comfort from you and the minister. How can the in a want to legislate, giving the second position to us, we want to legislate, how can you comfort us with this provision given now? That we should address the content, because at the tail end, we are saying in the interest of the country. So how you going to put to the fore? We want to give, but there's a caveat. How can that lie? Don't forget that sometimes there is disrespect to MP status, which we are fully aware of. There is disrespect. SO2, when we send letter to the old, and this and that, and for this, now, it's not about threatening people. We have responsibility to the state and our people, represent our people. So we cannot just give our contracts and share the constitution as if we don't know what we are doing. We are now asking for comfort from you and the minister, as I did for the regulation, for records. Can we abide by this provision under the second provision that we are giving Mr. Speaker? That is the question exactly. We want the state or the executive to know our officer responsibility cannot be limited. Cannot be limited. But if we are talking about protecting the state, we should be seen respectful. We should be seen working with Parliament under the provision that we are going to give it. Thank you, Mr. Chairman.
Yes,
Mr. Chairman, I think this clause actually shows how progressively democratic our government is. We understand the powers of Parliament, but as executive, we have deferred to the leadership of Parliament, to the Speaker, to be the sole person who certifies whether such a document should be disclosed or not. And where that is unclear, in 54(2), we have also allowed, through law, that the matter shall be referred to the High Court, which is an independent form of government from the executive. I think, Mr. Chairman, this point that the leader of government, business majority leader, is presenting underscores that democracy is at its best form in Sierra Leone. That the powers of the executive cannot be misused. We defer to you as Speaker, and where that cannot be resolved, we defer to the judiciary. And that in itself is the best comfort anybody can have.
yes, Chairman.
Well, have you ruled on this one, Mr. Chairman? Because this is it's another one that's very tricky. Just dealt with it, but I've seen another side which I want to bring to the attention of this side. Under 52, clause 52, I will take you back into page 45. The clause, the provision there is a member of the council. That's where we suggested even after the membership. So let's be clear on this one. It's the council. 52 deals with the council, and there we already talked about 2 years. When we come to 53, for the same kind of, crime, we are now an employee of ONS or any of the other agencies. There, a person who contravenes subsection 1 commits an offense and shall be liable on conviction to imprisonment for a term not exceeding 10 years. So we have two categories here. The council membership, we already said, not less than 2 years. And now we have in 53, an employee of the national security or agency shall not disclose. Now we're talking about the employees there. So let's look at it carefully. Council member, agreed as was already, that's not less than 2 years. And then here we have not exceeded 10 years. So let's look at the responsibility, the council membership, and being an employee of any of those security institutions.
Yes, proceed.
Mr. Chairman, I think it's a great point that the chairman has raised. And in the interest of equity and the committee, whether you're a council member or an employee, if you disclose information that harms the state, it should be the same. So we should say still consistent minimum of 2 years instead of limiting this to maximum 10, not exceeding 10. It's a minimum of 2 as we did for council members.
Yes, Chairman, are you done?
Yes, well, that was just my submission, and the CM has responded. It's up to you.
My only worry is that you don't have to take some of these things to court. Because when you go to court, documents in court are public documents. They are public documents. The moment you file, it becomes a public document. And if we are all talking about the security of these documents, you can't take them to court. I think this matter can be determined without recourse to the court. If the council that is responsible for security can endorse that indeed this is a sensitive document and classified, then I don't see any reason why we should go to court. So the moment you file a document, it becomes public. And what if at the end of the day, when you take these documents to court, at the end of the day, there's a ruling that indeed is classified. The document would have gone to the public anyway. So what's the rationale? So I think we should have a meeting about this and see how this is done neatly without having to go to court. Yes,
Mr. Chairman.
Yes.
I don't know what is really the best because there are, apart from this one, I think there are security matters in court as we speak. That has to do with serious litigation.
That has to do with classified information. Classified information.
They have a way of treating it.
No matter how you treat it, the mere fact that it's filed in court. Any document that is filed in court becomes a public document.
So we don't really know the mechanics of it. But let me come where I'm asking now. How do you determine principles of fair judgment or fair trial or principle of natural justice? They are accused person. You have to make sure that all forms of fairness given to that individual is tried fairly. Because the always of the fairness of the person in a suitable court of law. You cannot set any kangaroo court to try to convict the person. That's why I state.
No, we are talking about the disclosure of documents. Disclosure of documents. For instance, the parliamentary committee here summons the chief of defense staff and instructs him to produce, or summons the CISA, the Director General of CISA, and instructs him to produce certain documents. And okay, I certify, or the council certifies that it's classified document. These documents cannot be disclosed. Because even when you bring these documents to Parliament, by bringing them to Parliament, they also become public documents. So if there's a certificate to the effect that these documents are classified, you want to file, you want to go to court to determine whether they are classified or not. You can't go to court without filing those documents, filing your application. And when you file your application, you have to exhibit these documents. And by that filing, the filing is public. The moment you file, it becomes public. So I'm just thinking aloud. I'm just thinking aloud.
Mr. Chairman, I think I agree with you. That is why in most jurisdictions, but even here, most classified documents are written on the file classified. Even cabinet, when you go to cabinet documents are written on the file classified, meaning they are classified. So I want to suggest that every document that has to do with this office, the classified document be written on then classified. So when once that particular document is linked out, you don't need to answer that or it was classified or not, because it is already written on it.
Mr. Minister.
I think if you read 54, the level of documents, the type of classification as it exists, whether it's secret or confidential or classified, maybe is captured in one. I want to agree with you, Mr. Chairman, that we remove 54.2 actually in its entirety and leave the council and the speaker.
Certainly.
And because the issue is specific to Parliament, it says disclosure before Parliament.
Yes.
And it's not for public.
So it is only for, let's say, the DG of CISA or the security person or expert involved to come to the speaker and explain.
Yes, as a
and
caption.
explain.
So I do.
The speaker can now do a certificate to that effect. Or you can go to council and explain, I have been summoned by Parliament, or I have been summoned to produce this document. Council can now certify that no, this is classified. I think it stops there.
I think, Chair, because it's for Parliament, so 54, if we just limit it to the speaker certifies that, and then the council certifies that, and
so
then
it does not go out.
Yeah.
I don't know whether that makes sense, honorable members.
Mr. Chairman, let me come now. You see, some of these provisions are constitutional provisions. Yeah. 104 the Constitution. Mr. Chairman, let us take a look at the same provision under this one. It took this one from the Constitution.
104.
104. Yes. No public officer shall be required to produce before Parliament any document if the speaker satisfies that. And now, okay, A, the document belongs to a class of documents which will be injurious to the public interest, from the Constitution, or prejudicial to the security of the state to produce. Or B, disclosure of content thereof will be injurious to the public interest or prejudicial to the security of the state. And 3, where, now come where they are talking about, where there is doubt to whether any document has is referred to subsection 2 is injurious to the public interest or prejudicial to the security of the state, the Speaker shall refer the matter to Supreme Court to determine whether the production of the disclosure of the content of any such document will be injurious to the public interest or prejudicial to the security of the state. What they did here, they just remove where you have the Supreme Court and they put this in the High Court. So it does copy, remove the Supreme Court and put in the High Court. So instead of removing it, we are looking at constitutional provision also. So I don't know how to play with this. But for me, we leave it as it is on nature of securing our state. Whether you find, even when they are fine, I know what you're talking about.
You know, the way the Constitution is made, the Constitution is the ground norm, is the law from which other laws, emanate. Sometimes what the Constitution does is state things generally. But now when you come to specifics, as long as your specific law is not in contravention, not at back, but you cannot create something special, as long as it is not against the spirit of that Constitution, that is correct. This is the general provision provided by the grown law. It is now for us to look at the specifics. And of course, what we are doing here, the security bill we are dealing with, is extremely serious. It's extremely serious. No state survives without proper security mechanisms. No state. And if you tell me about filing a document, a security document in court to determine, then you have contradicted yourself. Because anybody will tell you that when you file to court, it's public. You are hiding something from the public and you take it to the public. That's contradiction. You want to say that, of course, when you say public interest against public interest, yes, you can file that one. There's nothing wrong about, filing this. But for security, then you take document, classified document to the public, then it's contradiction. I don't know what you think about it, Mr. Minister, but it's huge contradiction.
Mr. Chairman, I'm not contradicting. I'm just saying what you stated.
You're right, certainly.
But let me come to let me digress a bit. The business of it is addressing specific issues that has to do with security principles. In the Constitution, the side notes for 103 going to 104 is the immunity for publication of proceedings. What you are addressing, the immunity for publication of information of proceedings. Subject to the provision of the Constitution, no person shall be under any civil or criminal liability in respect of the publication of the text or summary of any report, papers, minutes, votes, or proceedings of Parliament. We start from ourselves. And B, a contemporaneous report of the proceedings of Parliament. That is B. Unless it is shown that the publication was effected maliciously or otherwise in want of good faith. Otherwise, in want of a good faith. And it now came to 104 specifically we are talking about. So they have stated the immunity of publication. Every site in Parliament as an example. And when I came to 104, which they copy, they don't remove Supreme Court and put High Court. And specifically talking about the security issues here. And what we are addressing security matter. So what they only omitted is Supreme Court and High Court. In addressing the issue of security matter. It still has to do with disclosure of what you have said carefully by your application of proceedings in court, which you said is public document. You are right. But I say the privileges and the immunities. So we're dealing with this. We know it can be public document, but it has to have clarity. What if I'm disqualified to court for? This is different. I see it different from the normal proceedings, normal file, normal what affidavit is signed for the court. This has to do with some guided principles coming from your good office and also the interest of the state account of security matters. I think that it's because they cited the constitution and they just copy verbatim, just changing the word there to play the other one. That's my purpose. So if you remove this star by the minister, he something is missing.
Mr. Minister, what do you say?
I think, as you said, Mr. Chairman, that the constitution is the ground. It exists anyway, it's sacrosanct. And when that matter arises and you as speaker will need to go and make a judgment, as stated now in when there's doubt in 54.2, you will go by the constitution, you will go to Supreme Court. Going to High Court here defeats the purpose.
Yes, that's it.
And so I think we should remove 54.2.
Yeah, because I think there might be some special provision in the Supreme Court which you cannot find in the High Court.
Exactly.
And there's a special, we have the Supreme Court rules, we have the High Court rules. Maybe there's a specific kind of rule dealing with this in the Supreme Court.
Mr. Chair, I agree with you. The National Security and Central Intelligence Act establishes the NSC, which can act as cabinet. It makes decisions on its own. And I think that we should leave it with 54.1 and allow you and the council to make that decision. And on 54 to remove that. And when that doubt exists, we go with the constitution.
Of course. Of course. Are you okay with that? Are you okay with that?
Constitutional provision.
Leader government business.
Yes. Constitutional provision. We are talking about the protection of privileged information and secret information that we refer to them as confidential information. And in tandem with the constitutional provision starting from 103, citing the parliamentary proceedings, contemporaneous reports. We are talking about also other parliamentary reports. And we are now questioning, in as much as you have the privilege of having this, you are not, it's still within the proper domain. Going to the Supreme Court is different going to the High Court. So what they have done in the spirit of the drafter of this law, they have brought it down using the same text. They have brought it down to the level of the High Court so that this matter can be addressed urgently. But the reason why they have done so, Section 93 also is talking about the High Court. Because we sit like High Court representatives. We sit like the High Court. We don't sit like the Supreme Court. And this document has to do with disclosure of document that has to do with maybe Parliament, yeah, and also confidential information we are addressing before Parliament. And this time we are talking about giving a penalty where you fail to disclose. So for me, giving a constitutional provision in same vein, in the same spirit, now it's let us remove like that. I see that we have problems with having a super clause. We have problem with this provision we have above. So to say we don't remove, if you go, it's dealing with disclosure before Parliament. And Parliament disclosure section 93, 5, I think, has to do High Court. If you don't mind, I can go there. 93, 5, Mr. Speaker. 93, 6, not 5, sorry. 93, 6. This has to do Parliament. Now, 93, 6. For the purposes of effectively performing its function, each committee shall have all set powers, rights, and privileges as vested in the High Court, as a trial in respect of blah blah blah. So we are saying
what that one is saying is distinguishable from what we are saying now. In this case, this one refers to reference. For instance, we are dealing with an issue here that is inconclusive. We want to refer. Most of, I think, everything related to parliamentary references go directly to the Supreme Court. Everything related to parliamentary reference goes direct to the Supreme Court. I have not seen a case where we have to deal with the High Court. This refers to reference when we are referring a matter to be determined. From Parliament, it goes to the Supreme Court. I've not seen a situation where we have to go to the High Court. The only thing about Parliament that we go to the High Court are maybe petitions, parliamentary petitions, election petitions, and so on. But references from Parliament normally goes direct to the Supreme Court. Probably that's the more reason why I think the Supreme Court might be better than the High Court. Do you have any particular thing against that?
Mr. Chairman, I just again looking about, I still want to fit myself into what I've suggested. I'm still on the edge. I still want to feel, I still go back to the spirit of enactment. The spirit of enactment. That it has not caused harm. It has not caused harm. They have been working with it. To be very honest, you want to raise the bar for what comes to Parliament, I can understand. But this functions and the security law, National Security and Central Intelligence Act 2023, this provision, they need to tell us. They are operating with this law. Has it caused any harm? You do the High Court. Has it caused any harm? If it has not caused any harm.
Have they been there before?
But that's what I think.
That's the question.
So it's silent, it has no harm.
Have they been there before?
Well, we
do
don't
you
know.
have any knowledge?
I don't know. Except we have to ask. So coming, because this is addressing that particular issue in 93. Why 93(6) talks about High Court, not Supreme Court? Why? And it has to do disclosure. This provision also, where there is challenge in the production of the document or whatever evidence you are asking for, it brings us to the level of High Court. So bringing it to Supreme Court, I'm trying to fit in a matter as a higher killer. It's a higher killer. I'm trying to fit myself into it. Why we should take it to Supreme Court. Well, as I said, I read this provision. It has not caused any big deal in the existing act. It might be something that will cause today. We are sitting here. They will still use this law, no matter what publication. So in the spirit that they have something that is still a bit different, they have decided to take upon this provision to also make it very useful, not going with the sacrosanct law in the Constitution is the Supreme Court.
Is the DG for CISA here? Are you here? Talk with the minister. Mr. Minister.
Yes, sir.
Have a conversation with the DG CISA and let's take it from there. No, we are not standing. We don't understand. Yes, Mr. Minister.
Mr. Chairman, I think you are the leader of the Parliament, and you also are a lawyer, luckily for us. And the point that you made about by bringing this to court, it makes it a public document. We should be guided by that. We should be guided that, as the leader of government business said, this is not just about any documents. These are documents that are classified to be injurious to public interest and to the state. And if through this process of doubt, it's just doubt, it exposes those documents to the public, that then becomes injurious to the state through the process. I don't think we want to.
And the only reason why we are here is to protect our security architecture.
Absolutely. So
we end up making a law to expose some of these things. Then why are we here?
And I know that there's a school of thought that says it has not been used before, so it's not because but it can be used in the future.
Yes, they have not tested it, so nobody will know.
I think that we would defer to you on this matter and say, if it stays there, it's been great. It's not caused any harm. But if it has the potential in the future to expose the state, then I think we should remove it.
Yes.
Mr. Chairman.
So, Mr. Leader, do you have any problem with that?
Mr. Chairman,
we are missing something. No, we are not missing anything. Let's not forget that we go on the advice of the minister that is fighting to repeal. We have guided him, and he's seen reason, and he has decided that yes, I think we did not give this one a toss, but I think it's good that we remove this one.
Mr. Chairman, let me come here. Let's go back to the text for some reason.
It seems you like winning arguments.
I'm not winning. I like to be realistic. And when I'm making laws, I want to be clear in mind when I sit back reflecting what I've legislated. I'm very clear in mind because these laws are to be in the public domain. Like we did the amendment for having public elections law, public elections on a specific date. After we know by a typo, we have sent out one to have a specific date of election to referendum. The Open Public Elections Act, it is there. So a senior citizen who goes to parliament, you're blasting us all over the place. And we take blame for that, whether you like that mistake we have done or we did it deliberately, we take the huge chunk of that. And I don't want anybody to blame me in particular for what you have done. We are talking about preserving the sanctity of the law and sacred documents. The provision is coming in where there is serious doubt and there is challenge that the document should not be disclosed. That this document should not be disclosed. That's why it's where there is doubt and there is challenge in provision that document. So I think in the other way, they are speaking the same language, but for me, I'm saying it as verbatim as it's in the law. So when there is doubt that such document is not in the public interest and should not be disclosed.
There's already a provision.
No, Mr. Speaker, even in the Constitution, when it comes to parliament,
don't blow hot and cold.
No, it's not.
You have referred to the provision in the Constitution. It doesn't mean if we delete it here, it does not still exist in the Constitution. You can still use the Constitution to go to court. But at the Supreme Court level, where we have rules dealing with that, that's what we are saying. So it's the same thing, they are saying the same thing. It doesn't mean by deleting it, they can still not go to court. But
I know what the paragraph is. Mr. Chairman, he said, you have 20 years or more as a practicing lawyer. With all due respect,
sometimes you should be listening to me, huh? Because some of these laws you make, you are not tested.
I am not tested them. That is why lawyers are not the best people to be. It's the ordinary.
No, they are the best.
No, it's the ordinary person.
Because they have tested.
It's the ordinary person.
You have not tested any law.
Mr. Chairman,
you don't make them as a civilian.
It is the same law we are making. That's why it's difficult for lawyers to make laws. Because then you make the laws and they interpret the law. So that makes it very difficult. It's difficult for us to make laws. When I'm making the law, they interpret the law. For me, I'm making the law on common sense. That's where I stand.
Law is not common sense.
No, make the law on common sense.
Leader, law is not common sense.
All right, let me proceed.
No, let me correct you. Law is not common sense.
Noted. It's logic. It's logic. Mr. Chairman, they brought it down to high court because Supreme Court is difficult to constitute.
No, stop that. Stop that. Stop that.
Mr. Chairman,
stop that.
Mr. Chairman, allow me to raise my case.
No.
Preside your officers and Mr. Chairman. Let me make my case.
Don't even go there.
Let me make my case. They sat on this bill. They went to cabinet. Except the minister wants to tell me that is why in fact by law, it's because the Attorney General is very, very busy.
But every bill by law should be piloted by the AG. That is the sacrosanct law. They are delegates.
Would have agreed with me ever since.
Let me come now.
I can understand.
They stated the provision in Constitution section 104, and they came in the spirit. What I sit here as common man, logically, so from then, in my own thinking, is that they are looking at the ramifications, going to Supreme Court and dealing with these issues immediately as possible at the High Court. Take into consideration my statement. If you may want a minister, they will remove it. But let me be on record that they have not put High Court.
Put the leader on record. That is
and they're recording me, don't worry, sir. They have put High Court because they want this matter to be resolved, dealing with Parliament in particular. That is why, quoting the 104 of the Constitution, they decided to restate the provision and remove the Supreme Court and place the High Court. So, this argument is this. We ask, if you want to convince us, why not Supreme Court? Why do you not use Supreme Court? Why do you not use High Court? Because we know how Supreme Court sits. We know how High Court will sit.
Do you know that?
I rest my case, Mr. Chairman. Let me know.
Do you know that is the proposal?
Of course, but there's a spirit. The proposal has a spirit of the law. It's a spirit of not tracing. I have the act, the same repetition, 104.
Don't go on and on and on and on.
Mr. Chairman, if the minister want to accept, I'm not going to operate this law. They are sitting here, they are going to operate the law. Already it is the law.
Yes.
Let me answer.
Yes,
let me answer. If they want to remove it, as you said, the law is the constitution is going on, is clear. If they had wanted not to use this law, they shouldn't have stated it in the law. They shouldn't have gone to ask a proposal.
I have not said anything different.
Yeah, so I'm coming absolutely different. You said don't take back to Supreme Court and remove it entirely. I'm saying there is a good will. Why they have stated High Court, changing the only clause in 104. But if they abuse the minister, which is professional in consultation, I rest my case. But that's my position.
Thank you very much.
We want to hear from the minister.
Thank you very much, leader, for resting. Yes, Chairman.
Thank you very much, leader and Mr. Chairman. I hope you're not discussing what you already discussed here.
Yes, thank you. Yes.
I think you already said it.
These are very, very clear. You know, when committees sit, they sit as the High Court. You know, the leader already stated that. Then you take something from the High Court, you take the same thing to the High Court again. No, we sit as High Court in committees. So we cannot refer our matters to the High Court. We go to the Supreme Court as stated by the Constitution. Yes, Mr.
Chairman, if I want to make a point, I move the motion. I want to move the motion. I have brought it for a proper discussion. I thought we are saying when they sit, I not drew attention to the level of Parliament and High Court. Mr. Chairman, no. I want it to be stated that I exactly what I said for the High Court is to say the level of where we are being. I said, Mr. Chairman, allow me. I said, why not using the same provision in the Constitution, section 104 as Supreme Court? They transposed it in the same provision in the paying as High Court. They brought that to High Court. I've asked why. Why not Supreme Court? Why High Court? And let me come again, Mr. Chairman. In the Act, it is there stated. The professional minister, they are not convinced us why they should remove it. They are not also convinced us why they brought it down to Supreme Court, High Court, not Supreme Court. I rest my case. But if you force me to sit, I will put a motion and I want to see why I will lose that motion.
And if you put the motion, I will not put the question.
No, Mr. Chairman,
I will not put it.
No.
Just to tell you that I rule here.
No, Mr. Chairman, no.
Yeah, Mr.
Let's not fix it all. Please don't go that way.
Mr. Minister,
please don't go that so far.
Yes, proceed.
Mr. Chairman, I think on this matter, we would defer to your guidance. And for us, we think that if it is removed, it does no harm.
No harm.
If it stays in there, it's in there. So we defer to your guidance.
That's for page 47 also. Page 48.
Well, Mr. Chairman, no, before you go, Mr. Chairman, still my question has not been answered.
Yes, proceed.
Mr. Chairman, my question has not been answered.
Which one?
It's on the same provision.
The provision, which provision?
I said, why not Supreme Court maintain the provision of the court? As you stand here, the law is the law. As you stand here, as you sit here, as you speak here, the law here now, and that same provision is in existence. It's not a law. Even if you pass,
we have not resolved this matter.
No, we have not. Nobody is able to explain to me.
I'll take a date very soon.
Nobody.
I'll take a date.
No problem with you, sir. Nobody has told us why the High Court, not the Supreme Court. Why the Supreme Court, not the High Court?
I will adjourn this city. Resume the house.
Mr. Chairman,
Resume the house.
Mr. Chairman, you need to adjourn the house.
I will adjourn the house.
The house is no, Mr. Chairman. Mr. Chairman, we need to adjourn the house. We need to discuss the issues. Mr. Chairman, we need to resolve the house. So resume the house. The house is yours. Mr. Minister, you are pilot in this bill. We cannot just adjourn like that. We should be seen discussing the issues.
If we are ready to make progress,
no, if we have agreed,
if we are ready to make progress,
I have asked. We have asked.
Otherwise, I adjourn this matter.
No, you don't adjourn that way.
Are we proceed? Are we ready to proceed?
Let's proceed. Let's proceed.
Okay.
We are proceeding. Asking us to move on because we have not accepted the provision. Can I speak to you?
Yes, sir.
So there is no harm to Supreme Court to the also to proceed.
No, I think Mr. Chairman.
Yes. You want us to go back to the committee stage, Mr. Minister?
No. Finish it here. Finish it.
Mr. Please, I would like to ask Mr. Speaker that we continue in the with the debate.
Let's go back to committee stage.
The House is also the committee of the
to
whole.
understand. Yes.
And to respond to the majority leader, by removing it, the Constitution still remains as the law. We're still guided by the Constitution.
There's nothing wrong.
So it doesn't do any harm by removing it. We don't have to, essentially, as you have rightly said, this was extracted from the Constitution. But we can copy and paste everything in the Constitution here.
We have been the same thing over and over and over again.
The same thing over and over. They first remove Supreme Court and they brought to High Court.
It's a serious matter. Serious matter must be dealt with.
Very serious to remove a constitutional provision for High Court that has to do with disclosure and bring it to High Court.
Leader, how can you be supporting the High Court against the Supreme Court for a matter as serious as this?
So why can we, as legislators, pass that provision in that of 2023?
It's all right. We are deleting this provision, and we maintain the one in the Constitution. Proceed.
Mr. Chairman, shall we proceed? The minister said we move from that to the Constitution.
We maintain the one in the Constitution, we delete this one.
Yes. So
as easy as that.
We say we put a motion removal. Yes, for the record.
We are not putting all those in favor of removal.
No, there is no motion now.
No.
Mr. Chairman,
I'm putting it to you now.
Put a motion here, presiding officer.
I am putting it to you.
Don't put a motion.
Do you want us to adjourn, Mr. Leader? Don't keep up. We are keeping all of us here.
No, Mr. Chairman, I'm not going to put a motion. Then you ask for vote. You should not put a motion.
I'll put a motion.
Mr. Chairman.
As far as
now
what you want.
Mr. Minister, listen.
No, listen. You see, if you really understand the standing order, hold on. If you really understand the standing order, then you will know that anything I do here, I sit here
as the procedure of parliament. If you don't know, I sit here as the procedure. There's nothing. Whatever I say here is final. Don't take me to that next, please. Yes. Yes, proceed.
Mr. Chairman, Mr. Minister, for the progress. Let's continue. I do understand this paper really well. So, let's proceed. But we put motions and you decide on us. Thank you. Let's proceed.
Yes, Mr. Chairman, we've had discussions on fines, penalties.
Where is that?
Now we have, I just want to bring to your attention, let's agree on something because they are about what can be taken to court or also where we just want imprisonment and not monetizing the criminality. So let's take a look at 56 again and 57. We have for personation and obstruction of duty. As it is, we have 20,000 leons. Yes, the report we maintain the not less than or cause 5 years or to go to such and fine. So let's just house an agreement on that.
Where is that? That's 56?
Yes, 56 and 57.
So we find not less than 20,000.
Yes.
Instead of exceeding.
Yes, or term not less than 5 years or to go to such fine and imprisonment. Since you have some.
Is it not less than or not less than 1 or less than 5? Which one?
Not less than 5.
Not less than 5.
Yes, so let's look at it again because again security matters.
Not less than 5.
So we have not less than 5. Again, let's see if let's confirm in as much as the report was actually adopted in that. But again, the discussions there are sparked fresh interest in terms of fines. So we still maintain what the report stated earlier on about not less than 20,000 imprisonment or not less than 5 years.
Both.
To both. Yes, to both. So
are we in one or the other or both?
Yes.
You can say either not less than 20,000 euros or to imprisonment for a term not less than 5 years or to both such fine and imprisonment.
Yes, that's what we report.
Yes.
Still accepted.
Yes. That's for page 47 also.
Yes.
Page 48.
Page 47, where it also applies to page 48.
Okay.
There we have obstruction of duty. Okay. But then again, page 48, was 59, we're talking about repealing there are things we really need to save. So we're talking about possible repairs and savings. So it's back again to the minister and team. Okay, to agree on whatever that we might need to save going forward.
Is that 49?
Yes, that's 59.
59, okay. That's for page 48. Yes, Honorable Tenwe.
Yes, Mr. Chairman, on 48, paragraph 58, that speaks to regulations. I'll read. It says, the council shall by statutory instrument make such regulations as it considers necessary for effective implementation of this act.
Okay.
So I see the council as a given power to make regulations, but without strong checks. So I want to propose that we add just beneath that clause, all regulations made under this act shall be laid before Parliament and shall not come into force unless approved by Parliament.
Yes, Chairman. Chairman?
Yes.
Mr. Speaker, before the chairman resumes his seat,
Yes.
I just want to take you back to 7 briefly.
So 47.
Yes, the fine, that no less than 20,000. That fine is small for me compared to the term of imprisonment, 5 years. What should be
when they not less than 20, can mean 200. I mean even 1 billion. It's not less than 20. So depending on the seriousness of the offense, that can be taken to even up to 1 billion, 2 billion.
so what Mr. Speaker, can
Me,
you
the not all man get money.
Yes.
Can you permit me to suggest?
Yes.
Not less than 50,000.
Not less than 50.
Yes, impersonation is a crime.
And it's a very serious.
It's a very serious crime.
Mr. Chairman.
Yes.
Mr. Chairman, I just want to thank you. Personation is not monitorized. Obstruction can be benefits goods.
Yes.
But let us treat personation as a single entity. Yes. To be imprisonment.
Oh, we leave out the fines.
Yes. Let me imprisonment. Yes, you are right. Thank you very much.
So we leave out the fines.
Yes.
Just imprisonment.
Yes.
Not less than 5 years.
Yes.
Yes, it's serious.
Very
Mr. Minister,
serious.
you agreed also?
So
You agree?
Mr. Chairman, I do.
Okay, thank you. Mr.
Okay,
Chairman.
yes, hold on. Mr. Clark, take note. Mr. Clark, take note. We delete the fines and we leave that to the imprisonment.
Yes.
Not less than 5 years.
Yes.
Yes,
So we're removing monetary aspect. Yeah.
yes, the fines.
Mr. Chairman, we, as I said, we already have existing legislations. So, according to first attempt to talk about late and proper parliament regulations, we already said in one of the provisions that the president, under ministerial responsibilities, the president, we have talked about laying of reports. They can assign the regulation to any minister to come in. Specifically, it can be the chief minister, it can be the AG. So this one can be dealt with under the provision of the normal law, under statutory instrument declaration.
Which one is that?
They were talking about regulation 38, the answer to section 58, regulation 58(2). Without prejudice to the generality of subsection 1, regulations made by council shall provide for matters on discipline of officers